Okay, in this video I'm giving you a very broad overview of what we're going to be doing this semester, but getting a little bit more specific into the content and kind of just getting you introduced to these core areas. So we're calling this Introduction to Problems in Criminal Justice, the Legal System, Part 1. So I've pulled some of the learning outcomes that are required of you as you go through the criminal justice program, and just kind of to put this into context, you want to be thinking about the connections to the Academy of Criminal Justice Sciences if you want to be a professional in the criminal justice field. If you're transferring to John Jay, which most of you are, if you're criminal justice students, you're automatically accepted at John Jay and you're in something called the Justice Academy, then these are the main things that we're supposed to be learning about. And I pulled out the things that are particular to this particular class. Things that we want to make sure that we're talking about and thinking about throughout this process. But there are two concepts that are difficult that tend to get in the way of getting a good understanding of those other learning outcomes. The first is the malleability of law, and the second is the polyvocality of legality. It's because this challenges your motivated reasoning. You're often given a question or a possibility or a case study, and then they say defend this thing or argue or see two sides. The dilemma is that within legality there are three ways of seeing that we know for sure, before the law, with the law, and up against the law, that people experience the legal system in different ways depending on what their social position is, how much power they have, what they think they're able to do. All of these things have influences on how people articulate what they think law is, which we call legality, and the polyvocal just being multiple or many voices. So there are many voices of narratives about law. So there's not one single answer. So your desire for a single answer and the idea of arguing one side doesn't work well in this class, or any really legal classes. The second issue is something particular to the legal system itself. It's similar to the scientific method in that you've got a hypothesis in science, and here we have a case ruling, right? And so it's not one single answer. It's a ruling that applied to that specific set of facts, just like your hypothesis is related to whatever thing you're studying. Let's say in the lab for your biology class. But it gets different because these aren't scientific truths, right? In biology and science, you're studying, let's say, the anatomy of a pig, right? You're studying to see whether you can identify a particular organ in that pig. And that's an external scientific truth, right? The details of that organ, it does exist. You're looking at the blood or whatever. Whereas here we're looking at something called legal fictions, things that we're establishing as a kind of truth, or an accepted set of facts that we're saying is truth enough to come to a conclusion for this particular set of problems. And so this is internal to the legal system, right? So it has its own way of thinking, or we say something like legally speaking. And so this is difficult for students because it doesn't seem right, it doesn't seem moral, or it seems like there are a bunch of loopholes. In some ways these are all true, right? But nonetheless, it is what it is, right? So learning the multiple experiences and points of view and understanding that, and then understanding this latitude that legal practitioners have when they're arguing for and against something within a reality of not truths, but accepted conclusions that are always constantly being tested and revised, makes this class a little bit easier once you start just accepting those realities and kind of moving beyond your motivated reasoning or looking for a single right answer. So, for example, oftentimes students think when we ask what are laws or even what are rules. Well, we ask what are laws, and students usually say they're rules. So we say, okay, what are rules? And oftentimes, what students are talking about is the second category, the rules that are forbidding some certain type of behavior, or else you're going to have a consequence. And sure, law is those things, right? I mean, that's true. But that's not all there is. And so when we think about marriage, for example, it says, that's a set of rules that who says can and cannot be legally married, when a divorce can happen, what assets are going to be divided, how children are going to be, overseen. But these are not just rules that have consequences. Some of the rules don't have any consequences, right? They're just a formal way of organizing a dispute or a difficulty into a set of obligations, a set of processes, things that what we say here lead to other arrangements. So these create rules about rights and obligations that kind of create rules about rights and obligations, right? It kind of goes and goes and goes and goes. But there's no real punishment. You don't have to do it. You don't have to get divorced. You don't have to get married, right? So rules is beyond just a punishment, right? And so it's really important to start to understand that, in fact, laws are mostly not about rules forbidding behavior or a penalty. There are a lot of them, I think, right? But it's not the majority of the laws. So what do courts do, right? They don't just apply rules, right? They have to determine what the rules mean, all these conflicting rules, all these contrasting rules, all these layers of rules, and then they have to figure out, have they been broken? And if so, then if it's a criminal case, they're going to assign a punishment, or if it's a civil case, they're going to decide some kind of compensation, retribution. So that means there's only certain types of laws that constitute a court or legislature, right? So to think about it this way, tribal rules, laws, customs, conducts, habits, those don't necessarily create courts or legislatures. And so you've got a whole set of rules that really don't have anything to do with the courts or legislatures. That's not as common in a city like New York City, but if you go into smaller areas, and even some neighborhoods in New York City, there are customs and conduct that are separate from the court and legislative system. And so that's another thing just to keep in mind. Again, it's not the norm, it's not common, but it does exist, right? And so you want to think there's so many different types of rules and different ways of applying those rules. You want to just keep that in mind. And then you want to think about this thing called alternative dispute resolution, which is a formal structure, so it seems like law. And then there's a more informal structure, and I think like a Judge Judy is like in between informal and formal. It seems real, but it's mostly acting, and it's really not following the same processes and the rules that we identified above. It's still referring to some rules, especially the rule to contract, and that's what's creating this, let's call it a mock court or a fake court, versus an actual real court. They're all governed by different sets of rules is kind of the point, and alternative dispute resolution really makes that clear, that there's lots of other ways that you can go through legal processes. So you want to keep 3 questions in mind to kind of keep you sane. As you go through it, you want to think, how does violence or coercion, which is the same thing, coercion, making you do something or else I'm going to hurt you, which many of you are saying that's one type of rule. So then how is that different than laws, right? Simply going up to somebody and beating them and saying you'll do what I say, that doesn't automatically make you a police officer, right? Or a lawyer. And so what's the difference then between violence, coercion, and what we're calling laws? How do legal obligations and moral obligations, how are they different? Lots of people want them to be the same thing, so you want to start separating them and saying, well, what's the difference between moral obligations, oftentimes what people should do, and legal obligations, which is oftentimes what they must do or must not do. And then what is this idea of a rule? We just identified so many different types of rules and ways of thinking about rules. So does a rule really exist? And I pulled out, kind of to underlie all these points is just to have you walk through the divorce process and just look at all these questions, right, that people already have, even though, there are laws about divorce, right? So even if you know of the laws and it creates this structure and there's a court and all these things, go on, there's still lots of questions that have to be answered and lots of things that aren't clear. So, this should be no surprise, but many of you come into this class thinking that courts are perfect places and that judges are neutral and never do anything wrong. This is just pure fantasy. And so in this class, we want to examine how these problems arise within the judiciary. because we all have problems, everyone, judges, lawyers, everybody. And so what we want to think about is under what conditions does that problem emerge or occur, and then two, what is the mechanism that causes or influences the problem to occur? What's kind of getting us to that issue? So the first problem we have to ask is the criminal justice system even a system? Systems have inputs, outputs, and shared goals. And so we want to try to see, is that true? Is that what happens in the criminal justice system where we have police, courts, and corrections? Well, what we see is that police have an input of stopping people, and they have an output of arresting people, right? And they have a form that they have to fill out, and that's the output. Here's the form, right? You were stopped and arrested. In theory, then that's supposed to go to the court system. They take that form, that piece of paper, and then they have their own piece of paper called an arraignment, and that's what gets the process started. Assuming we go through the process, then we'll get a conviction. We assume that the police officer stopped the person for the right reasons and that they correctly arrested the person and they clearly violated the law. And so the output would be a conviction. Or, if the jury doesn't believe it, or in some cases a judge, they find the defendant not guilty, then, that's the output. So assuming that they got convicted, they were found guilty, we'd go to the corrections, and our input would be an intake form. So we take the guilty verdict piece of paper over to the corrections, fill out a new piece of paper called an intake form, and then the output is you're imprisoned, right? And so what's in common? What's the common goal of those inputs and outputs? Well, it's to close cases, right? If the opening of the case was the stop, then the closing of the case is the imprisonment. And so each of these steps along the way is just a process to close cases, right? Case is opened, now we want to close it. The dilemma becomes, well, we've got some gray areas, or some pink and yellow and light green areas. What happens when a police officer informally stops someone, questions, and release them? So there's no real input, right? There's no paperwork process. What happens when a police officer formally stops someone, detains them, and arrests them, but the paperwork wasn't filled out correctly, right? In the courts, what happens at the grand jury level, right? So the police, all that work the police that did could then just get thrown out by a grand jury. On the other hand, what if they accept a plea bargain and they bypass the court system altogether? What if there's a directed verdict, right? What if there's a verdict that kind of bypasses most of the processes that we know about courts? How do we think about that and compare that to the normal, quote-unquote normal, even though it rarely happens these days, court process, right, of filing motions, pieces of paper, back and forth, for and against, discovery, finding evidence, presenting the evidence, seeing whether it's going to be admissible in trial, having a trial, is it a judge trial, is it a jury trial, and how do we even think about appeals in this alleged system? And then finally, with corrections, we have choices in the corrections system. There's probation, parole, home monitoring, versus imprisonment. So how do we start to make sense of that in this system? Well, what you see here is that even though there's the unifying shared goal of closing cases, each level has its own goals, and those goals can contradict aspects of other levels. And so it's a very imperfect system. If we're going to be generous and call it a system, it's very, very imperfect. And so, ordinarily in an ideal perfect criminal justice system, the investigators would have collected appropriate evidence, they would have done it constitutionally, they would have followed all the paperwork and processed the evidence following an appropriate chain of custody, and then the prosecutor would review the evidence, select an appropriate criminal charge passed as a law by the appropriate legislative body. You'd go to trial. The prosecution would present their evidence against the accused would respond, and the jury would determine guilt or innocence beyond a reasonable doubt. Right? Sounds like a pretty great TV show. So what happens? Well, if this was all there was to learning about criminal justice, you'd be done, right? You wouldn't need this class. You could just watch an episode of Law and Order and then you'd move on with your life. So we have to think about what really happens. Well, let's start with the basic thing. Most of the arrests involve crimes that were defined by local laws, right? We call these legislative statutes. So the spoiler alert is this is where everything's going to fall apart. We said in the last slide that hopefully that everybody would have done what they're supposed to do. Well, we could just start at the beginning and say, well, was the law a good law? Was it well defined? Is it current? Does it apply to the particular situation? Can you establish mens rea and actus reus? Right? There's all these questions right at the very beginning, and that's what we need all these books for, right? These are all the laws that have been passed by the legislature. And so in New York, that's the state senate. And so they pass laws and laws and laws and laws and laws and laws, and they've been doing it for hundreds of years, right? So there's thousands and thousands of laws. And then you've got this court structure that starts at the bottom and moves its way up. And so, each of these courts, the criminal court, civil court, district court, city court, county court, family court, Supreme Court, surrogates court, court of claims, right? They're all hearing different cases about different laws. And so now you've got thousands and thousands and thousands of cases that have to do with thousands and thousands and thousands of laws. And only some of those are going to get appealed because they have to be appealed on an issue of law, an error of law. And so not all of those, not even very many of the cases are really getting to the appellate level. And then very few are getting to the highest level, and those are only going to be ones that were very obvious errors of law that they're trying to correct to prevent the lower courts from making the same errors. And then if you just have time to go through and look at all the different laws of New York, you'll see there's just so many different types of laws, right? That I just pulled out the first 4 in alphabetical order here that show you just kind of, it's not just about prohibiting behavior. It's also about how to construct contracts and how to create new relationships and all sorts of things. So that's obviously a lot more than we're going to do in this class, but I just wanted you to see it gets very complicated from the very beginning. So then at the very big picture level then, big thing they want us to do is let's think about or talk about how do they organize courts, right? And so what I've done is I've pulled an image and description here from a open source American government textbook. So what you should have learned in a previous class, right, is that there's state courts and there's federal courts, and you would have learned this thing called jurisdiction, which tells you whether the state court can hear your case or whether the federal courts need to hear your case. And if you look over here at this nice pretty triangle, you've got the U.S. Supreme Court at the top, right? You've got these Court of Appeals and district courts. That's the federal government side. And then you've got the state appellate courts and trial courts. So you've got nice federalism here, state versus the federal. And, it should be nice and easy, right? And so we've got some examples here of whether it involves a federal question, meaning that your issue has to do with a very specific clause of the United States Constitution, some kind of law that's been passed by Congress, in very rare cases a treaty, or whether you're a part of the federal government. Whereas obviously most of your life is spent in a state, and so most of the cases are going to be in state court, right? And so one thing to point out immediately is what kind of cases do you think are happening in these courts, regardless of whether the state or the federal? And you'd probably be wrong. They're mostly business cases. They most have to do with corporations. And so, the organization can't just mean this pretty picture and then splitting things into state versus federal, because there's going to be issues in which state and federal laws apply. And so how do you choose which court you're supposed to be in? And remember, you can only appeal if there's a matter of legal error, right? And so how do you establish that? And so this is an ideal or a nice way of thinking about it at a very basic, kind of almost childhood level. But then we want to start thinking about reality, right? What is the organization, and using that word a little bit differently, of an actual court? And so here in New York courts, they have what they call problem-solving courts, and this one is mental health courts, which deals with a variety of issues, as you can see. And they've got other courts, human trafficking courts, family treatment courts, right? Lots of different ways of organizing the administration of justice through the court system. And so I just wanted to pull out some key principles here, right? This is how you think about organizing, right? When you're organizing your room, you're not drawing you could draw an image of your room, right? But that doesn't mean that your room has been organized. right? But if you have coordinated planning and administration, right? There's people actually maintaining, keeping your room clean or organizing things for you or moving things in, moving things out. There's a population you're trying to serve, so people that are coming into your room that you're working with, yourself, right, etc. There's a referral, screening, and assessment process, right? Some way of keeping everything organized and making sure things stay on track. There's individualized treatment plans here. These are legal documents that people come up with in consultation with doctors, right? And so there's a process there of filling out paperwork. Informed choice and voluntary participation, another set of legal forms that have to be gone over very carefully. There's terms of participation, how long something is going to happen, the scope, very much like a contract. There's looking for and working with community-based services, right? So the courts are having to organize outside of the courthouse. There's informal information sharing and confidentiality, ways of keeping information private. That goes to where is our files being stored, what kind of computer software are they using, how do they make sure they don't get hacked. And then there's judicial monitoring and making sure there's compliance going on, and there's a whole group of people who are employed to work on that. And then there's evaluation of the system itself, right, to look and see if it's actually working the way it's supposed to. So there's a lot more to organization than you can get on a triangular image, right? The other issue that you really want to think about are origin myths, right? Things that you assume were true as to why we have policing or why we have courts. You want to start critically analyzing any of those claims. And so, to think about one thing is that there weren't police in England in the way that we think about it until urbanization, until industrialization, until machines and corporations started becoming a part of everyday life. In fact, the rich didn't want to have police because they were trying to limit the power of the government, of the people in charge, and they saw police as a threat to their liberty. And so it wasn't until pretty big changes, technological and communication changes in England, that police were even really what you'd start to know as today, and they were mostly very aggressive and brutal. And in the United States, the history of the police is even more complicated in that it was tied to slave patrols, the KKK. And really the using police to get people out of their property, right, and take it over and give it to somebody else. And so in the United States, police has mostly been about protecting the land and keeping people off of it so that you can use it for money, to make money, profit, but also to keep people from working together and to force them into labor. And so these two forms of policing are both built on the use of violence and the threat of the use of violence. So you want to keep that in mind as reality, right? That's how we get to where we are today. So we want to go back to those learning outcomes, and now I want to give you a little bit of perspective to think about for this semester. There's no nature of the judicial process. It's a ridiculous learning outcome, in my opinion. Judicial process is not a separate entity. It's not alive. So what we have to do is describe the elements of the process, the steps. We need to name the actors, the judges, the lawyers, right, the people who are participating within the system. And then we want to examine their behaviors critically, not as if it was an ideal world, but the world we actually live in. We want to look at the belief that judges make law through the convention of common law, and this includes judges reviewing whether previous court's application of a statute or action to a new situation is correct or merited. We're going to go over that quite a few times, so that one will probably be a challenge until a few weeks in. We have to understand that the idea of judges making decisions is a result, right? It's not the purpose, it's not the intent. It was an afterthought, a consequence of having an adversarial system of common law. This leaves judges open to interpretations of these controversies, and they have to base their decisions on education, experience, and their professional values. And we collectively call these things norms, judicial norms, right? Which are different than, let's say, a CEO's norms, right? Or another place where people make decisions. Legislation, previous case law, custom, and conduct, those are all things that can form both criminal and civil lawsuits. So there's many, many layers and sets of rules. Within a democratic republic, lawyers and judges are seen as experts of legal subjects, and they make decisions for the public on those legal matters. The public has the right to modify these unelected powers through mobilization, but it's pretty rare that they do, and we want to think about why that is. Arranged as a tiered system to accommodate appeals based in errors of law. That's really the whole purpose of the organization of the courts. A high court established in the U.S. Constitution and judiciary acts to hear cases and controversies about federal issues of law. That's the Supreme Court, remember, being created as a special court to try to unify the different state courts, but that has not really worked out. There's no specific number of judges required nor specific requirements, except as those have been passed by Congress. So Congress gets to decide those things, and in theory, the people who elect them get to. There are competing notions as to whether a court judge should have the ability to strike down, overrule, or replace laws written and passed through democratic majorities, and I think that's worth thinking about every week in this class, of whether judges should have this right, whether they even really do, where they took this power. Criminal law is an area of law, right, that restricts certain behaviors. That's probably not news to you. Criminal procedures are rules of practice that apply to the lawyers, witnesses, juries, and staff within a criminal court, whereas the specific roles we're identifying here are rules of practice that apply to those areas, and they adhere to particular policies. So, for example, jury instructions, right? You can Google jury instructions for New York City, whatever you want, and you'll actually see examples of this, right, where each of the roles has their own particular things that they're supposed to do as it relates to jury instructions, giving the jury instructions about what it is they're supposed to be doing. Issues of justice and equity. This is a very big programmatic kind of thing, and so this is an understanding that law is not outside social democratic processes, right? It's in concert with, it works with, it constitutes, and to consider under what conditions equity and justice might exist and by what mechanisms. That's something that you'll want to be thinking about throughout the course, but especially as you're working on your presentations and your final project. So this is part 1. I'm just throwing a lot at you. In part 2, we'll get a little bit more into specifics, but you want to probably watch this more than once and just try to process kind of this really big picture, and then we'll start narrowing in.